Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel for the latest legal insights. Please like this video and keep the conversation going in the comments section as well. So there has been a recent change in the law in the Building Safety Act. Jessica Stanway is a property litigation solicitor here at JMW Solicitors. So Jessica, what is the Building Safety Act?
Yeah, so the Building Safety Act is a new piece of legislation, and it's been brought in response to the ongoing building safety crisis, which loosely refers to those problems sort of identified particularly in relation to the design and construction of buildings, which means that some buildings aren't compliant with normal safety requirements and has largely resulted in issues with, say, fire safety, like perhaps the presence of flammable cladding or inadequate compartmentation, and it particularly sort of affects blocks of flats.
Not everybody will have had an opportunity to sit down and look in any great detail at the Building Safety Act. So what does it mean? What are the important bits?
We can expect to see it come into force over the next sort of 12 to 18 months, and it brings with it a number of changes which, say, developers, freeholders and leaseholders really ought to be aware of. There isn't really time to go through all of those changes because it does bring in a lot, but I do think it might be relevant to touch upon sort of two of the key issues that the Act intends to address, which is who's responsible for carrying out those works, and most importantly, who needs to pay for them. So there has been a lot of debate over who is responsible for the cost of the remediation works, and also sort of the interim measures that have been put into place whilst those works are being carried out. By that, I sort of mean the installation of, say, new smoke alarm systems in blocks of flats, or the introduction of a waking watch. And the starting point for all of those costs, including the remediation works, is that those costs can be passed on to the leaseholders by way of a service charge. And we've seen over the past few years, leaseholders are facing excessive bills in the tens and thousands of pounds for those costs. The new Act brings with it the government's approach that they're now very clear that leaseholders shouldn't be responsible for those remediation works, and they certainly shouldn't have to foot the bill for those costs. And we've sort of seen this not only in the Act itself, but also in their response outside of the Act. So, for example, we've seen them make available more funding for those remediation works, and they've been calling on developers to sign up to pledges, and also asking developers to agree to contribute towards the funding available for those works. The Act itself brings with it stronger measures to compel freeholders and developers to carry out those remediation works. So, for example, it introduces powers to restrict irresponsible developers' ability to build new homes if they refuse to take responsibility. It also increases court powers in respect of pursuing those who are deemed to be responsible. So it extends the limitation period under the Defective Premises Act. And it also attempts to address deficiencies perhaps caused by company law, and it allows parties to pursue associated companies. It also extends the building safety levy contributions, which will be charged on all new residential buildings moving forwards, and make available more funding for remediation works. And it also brings in the concept of remediation orders to compel freeholders and developers to pay for remediation works, and hopefully it'll simplify the process in the long run. It also brings in a number of protection for leaseholders in respect of those costs which are capable of being passed on. And these protections will apply to qualifying leaseholders in qualifying buildings. It intends to protect those leaseholders that qualify from costs associated with unsafe cladding in full. And it's offering more protection in respect of those other costs associated with, say, non-cladding defects, and again includes those interim measures that I referred to earlier. If those costs are associated to the building developer, then it will be illegal to pass those costs on to any leaseholders. And it will also be illegal for building owners to pass on costs where they pass what is being called the wealth test, which is just where an owner has assets of £2 million per building that they own, they cannot pass any costs on. And where costs can be passed on, the Act is introducing a cap on how much leaseholders can be expected to pay for those works.
And Jessica, how can you help?
Unfortunately, I think for all those that are affected, whilst the Act itself is really welcome, and it is going some way in addressing those issues. The position is not going to be straightforward. Each affected building is going to be subject to its own facts. The circumstances in which the defects arose, and as said earlier, maybe the makeup of the tenants in the building. The industry is certainly expecting to see an increase in disputes and possibly litigation, particularly in the case of developers. And it's also going to be interesting to see how the Act itself is going to interact with existing legislation, I think particularly in relation to statutory protections in respect of service charges. And we are also expecting to see an uptake in disputes in the tribunal, especially for those leaseholders who have already paid for works, and whether the Act ought to take retrospective effect. I think it's going to be very difficult to navigate, particularly whilst the Act is in its teething stages and the secondary legislation is being finalised. But I think freeholders, managing agents and developers in particular should be preparing for those changes now, especially because the Act is suggesting it will bring with it more severe consequences in the form of remediation orders and potential criminal sanctions. It's definitely going to be worthwhile for building owners to be seeking advice on how the Act might affect their building before they embark on any sort of proposed works. And I think it's also sensible for developers to be assessing their portfolios now and seeking advice on the possible risk of claims.
Thank you for your insight. And if you'd like to speak to Jessica and the property litigation team, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please subscribe to the JMW Inside Man YouTube channel for the latest legal insights. I'm Dominic Walker, JMW's Inside Man.